Good morning and a very warm welcome to the 23rd meeting of the Education and Skills Committee. I remind everyone to please turn mobile phones off during the course of the meeting. We have a change of membership and I'm delighted that George Adam MSP will be joining the committee. However, he sends his apologies today and his substitute will be Dr. Alistair Allen. This is our last meeting with Dr. Allen and I'd like to take this opportunity to thank him for all his work over the years and wish him the very best in his new parliamentary duties. I would also like to welcome Professor Andrew Kendrick to the committee this morning. Professor Kendrick has been appointed as our advisor for the Redress for Survivors Historical Abuse in Care Scotland Bill, and we are grateful he can join us today. And I'll pause slightly while the alarm goes off.
This is a test of the fire alarm. Please ignore all messages until further notice.
Thank you. I'll persevere, but we may have another interruption shortly. So I'll move quickly to agenda item 1, which is a decision on taking business in private, and the members agreed to take agenda items 3 and 4 in private. Thank you very much. Agenda item 2 is main business of the morning, and it is our 3rd and 4th evidence sessions on the Redress for Survivors Historical Child Abuse in Scotland, in Care, Scotland Bill.
Attention, please.
Pausing again.
Fire has been reported in the building. While this is being investigated, stay where you are and await further instruction. May I have your attention? Fire has been reported in the building. While this is being investigated, please stay where you are and await further instruction.
Apologies again. To our witnesses who are waiting to come in at the moment. Can I please welcome to committee this morning our first panel, Kim Leslie, representative of the Association of Personal Injury Lawyers, APPL, and a partner of Diggory Brown, Una Doherty QC, Faculty of Advocates, and Ian Nicholl, Solicitor and Convener of Civil Justice Committee of the Law Society of Scotland. We are tight for time, so I would ask members to be brief and for witnesses to be concise in their answers due. I will now move to questions from the committee, and if I can remind members to put an R in the question room.
The fire alarm system. Please follow all safety announcements as normal. The test of the fire alarm system is now complete. Please follow all safety announcements.
Apologies again for the interruption from our fire test. Can I quickly move to questions from our members, and can I move first to Ian Gray, please?
Thank you very much, Convener. I'd like to ask the panel about the requirement in the legislation excuse me, for those who avail themselves of the redress scheme to sign away their right to pursuing civil justice. I think in all the evidence that the 3 witnesses and their organisations have submitted, they suggest that in their view this is not necessary. And my first question is to ask them to enlarge on that and make sure that we have that on the record.
Yes, Ms Leslie.
Thank you, Madam Convener. Certainly, I would welcome the opportunity of expanding on this. So you will appreciate that our organisations are legal representatives, and we see the waiver provision as being the most dangerous provision in the bill. And I represent a number of survivors, and I would like to put on record that the information that I'm getting from survivors is they're very concerned about this provision. The waiver provision benefits only the scheme contributors. The retention of the waiver provision is likely to make the survivors and their legal representatives more cautious about an uptake in the redress scheme, because signing the waiver will effectively waive their civil rights for all time coming. you're effectively expecting a survivor and their legal representatives to elect at a time when all the information is not necessarily going to be available. And what do I mean by that? The changes in the law have only relatively recently come in, so there's a changing, evolving legal landscape. The Scottish Child Abuse Inquiry is still undertaking their work and publishing their case study findings periodically, and therefore there's changes in the factual position as well. So my concern is that a legal advisor faced with any set of circumstances that are not black and white, for example, there is no hope under any alternative route, be that criminal injuries compensation authority or alternatively a civil claim. So unless it's extreme, so where there's no hope 64 case, or by contrast there's a convicted case where there's an identified and solvent defender, in all but those extreme cases, there'll be shades of grey where the legal landscape is changing all the time, and I think that this will prevent a legal advisor being confident at this stage to advise on the ramifications of signing a waiver. And I would say that because if you have a situation as well where there's a live perpetrator, there may be not sufficient evidence to go forward at this stage, but would one be confident enough to say sign a waiver for all time coming when there's a potential that prospects of success may improve? Thank you.
Thank you. Can I bring in Mr. Nicol and then I'll come to Mr.
Thank you. Good morning. I think there are a number of issues with this waiver. First of all, the bill requires a survivor to abandon existing civil proceedings. Now, it's maybe a relatively minor point, but abandoning an existing civil action requires the pursuer in that action to offer their opponent legal expenses for the work that's been done in court up to that point. Now, if you follow that through to its logical conclusion, one of the dangers of the scheme is that it undercompensates, and experience is that significantly higher awards of compensation can be achieved through civil litigation. But if a carrot is angled in front of a vulnerable claimant, vulnerable survivor, they may be tempted to take it. It could put them in the situation where they have been pursuing an existing civil action for quite a period of time, and they are then forced to walk away from that with no compensation from the defender in that civil action, and potentially having to offer the opponent their court costs, even if it can be negotiated that that civil action is terminated on a no expenses basis. The survivor of the abuse will still have to account to their own solicitor for the costs of the civil action up to that point. Now, it puts the solicitor in a conflict situation because they then have to advise that client on potentially settling a case without any recompense through the civil courts, and billing the client for the work that's been done up to that point in time. That is a fundamental flaw with the bill as it stands. The waiver, in my submission on behalf of the Law Society, is something that should not be kept in the bill.
Ms. Doherty?
To the consultation as well as the response to this bill, we have said that there shouldn't be such a waiver scheme, that an applicant shouldn't have to choose at the outset between accepting a redress payment under the scheme and pursuing a remedy in the court. I think both Kim and Ian have explained some of the reasons why that is. The potential award under the redress scheme may be much, much less than a potential award in court. The potential success of an action in court will be difficult for a solicitor to determine quickly and will involve quite a lot of work. And to expect all of that to be done without finance at the moment, because that's a concern that has been raised in the faculty's response. At the moment, an applicant, the costs of getting advice on whether or not to proceed under the redress scheme as opposed to litigation is not something that would be funded. That just cannot be right. It's a very, very big decision to give up the right to pursue an action in court. And as I say, the potential award in court would be could be much, much higher. Obviously, pursuing a court action is difficult, and that is something that potential applicant would have to decide in any event whether or not to proceed with that. But I think requiring an applicant to say at the outset that they would give up all right to court process is fundamentally wrong.
Thanks.
Yeah.
Thanks very much, convener, and thanks to the panel. I think that was very, very clear. The argument which has been put to the committee, which Kim did allude to, is that this waiver is necessary in order to make it worth the while of contributors to the fund to actually contribute, that they have to have this reduction in their liability in order to make it viable for them to participate. And I wanted to ask the panel what other legal remedy they could see which would ensure that contributors do contribute to the fund, because that also, we've heard evidence, is an important element of the scheme which survivors would like to see, that those organisations responsible for their abuse make a contribution. So if it's not incentivised through the waiver, what legal way would be possible in order to ensure those contributions?
I'll go back to the panellists in the same order. So, Ms. Leslie.
Thank you, Madam Convener. The situation here is that at present, we have to accept that it's not complexity that is arguing against the offset provision, because you will see in the scheme that it works the other way, that previous payments can be deducted. So the logic is just simply not there. So offset is certainly an available option. And one of the things that I would like to pick up, if I may, is as the bill is currently framed, an applicant may approach Redress Scotland without any legal advice. And it is only at the point of an offer where they are strongly encouraged to seek legal advice. That's when they have an offer or an award made. They then have 12 weeks at that point, and that point only, in order to assess whether or not there is whether or not they should accept the redress payment and sign this waiver. So in those circumstances, that's simply not going to be sufficient time for proper informed advice to be given. In relation to the cases, we have to take a view as to whether or not what optimally would happen is a redress payment would be made and an offset would be the optimal way of dealing with it. However, in a situation like this, there may be and there ought to be some safeguards if waiver is retained in order to pause at any point in the redress process to enable proper advice to be obtained. And in relation to incentivising the scheme, I think that there will still be an uptake by scheme contributors, because there will still be a number of applicants whose cases can resolve through this. even with removing the waiver. And I do understand that it is very important for accountability to be given. But nothing should be taken away from the survivor that isn't replaced with something better. And in my opinion, this is a too high a price for a survivor to pay.
Mr. Nicholl?
Thank you. Yeah, I think it's possible to make the waiver optional in the cases where there is no intention of proceeding with civil litigation. And in that situation, it's an assurance to contributors that they are not going to be sued, and they may be more inclined to contribute in that situation. But it's also important to bear in mind that there's no argument here for doubly compensating victims. So if they get there relatively quick, and it's anticipated that the redress scheme will be quicker than civil litigation, although timescales haven't been clarified. But if they get a quicker settlement through Redress Scotland and get their 40,000 or 80,000, whatever it might be, if they proceed with civil litigation, it's expected that there would be an obligation on the survivor to account to Redress Scotland to repay any compensation to avoid double compensation. They go to courts, say they get 100,000 and they've been paid out 40,000 by Redress Scotland, they would be obliged to repay that £40,000. And again, that may give contributors some reassurance that they are not going to be doubly penalised. But I think other than that, I would simply echo what Kim has said.
I'm going to move to Ms Doherty, and then we'll have some supplementaries from Alec Neil and Alistair Allen on this. So Ms Doherty?
Yes, so I think the question there was how contributors can be encouraged really to participate in the scheme if there isn't the waiver which is being suggested. I mean, I think that the difficulty is that normally a potential contributor would be entitled to rely on any legal defence that they have. So if there is litigation, if they have a legal defence, they could rely on it. It may be that potential contributors do recognise the wrongs that have been done, and therefore they wouldn't be defending civil litigations anyway. And it may be that they are prepared, therefore, to acknowledge their wrongs and contribute to the scheme voluntarily. If there is a contributor who doesn't voluntarily accept responsibility, then I appreciate that that's more difficult. And it may be that they would not be prepared to contribute to the scheme unless there really is some establishment of their liability. I mean, obviously there's the ongoing child abuse inquiry, and there'll be certain findings will be made there. So I suppose all of these things could influence whether or not parties are willing to contribute to the scheme. But I don't think that a fear that contributors won't get involved in the scheme is sufficient to justify the extreme measure of the waiver that we've already discussed.
Okay, I'm going to move to Mr Neil and then to Dr Allen with questions, and then back to the panel.
Can I ask two follow-up questions? The first one is, should there not be an element of compulsion in terms of the contributors here? It seems to me rather ironic if these are the organisations who were responsible, albeit historically, for these, that we shouldn't be in a position of incentivising them to do the right thing. They should be made to do the right thing. Would that not be the right principle to adopt, albeit the difficulty associated with that and any amendments to the bill? And the second very specific question is back to Ian Nicholl, when he said, in any case, the scheme undercompensates people for the abuse they have experienced. So in his view, or in the view of the Law Society, what should the levels of compensation actually be?
Can I ask Dr. Allen maybe to ask his question as well, and we'll come back to Dr. Allen.
Thank you, Convener, and thank you for your kind remarks. I was wanting to ask, perhaps on the back of a couple of previous questions there, just about the contributors and how the bill, I think the bill uses the term fair and reasonable contribution or something like that. And I just wondered if the panel had a view on whether they felt that was clear enough or what they understood fair and reasonable to mean. This is their contribution, I should say, the contribution by the organisation to the scheme financially.
Ms. Leslie?
Thank you. So in relation to Mr. Neil's questions first, I couldn't agree more. It's how I practice my role. I rarely call on people to do the right thing. I effectively have taken steps if I believe that there is a legal remedy for my clients in order to bring that case to a conclusion and deliver a result. But I can confirm that there have been a variance in attitudes in how collaborative and how forward-thinking organisations have been in dealing with cases. For example, it should be made clear that I appreciate that we are primarily pursuing financial redress, but in any negotiated case, we are entitled to ask for ancillary things like apologies, like a meeting with safeguarders, and these things. And so, what I would say is absolutely there's a range of attitudes to how organisations are dealing with this issue. And so I would say in a scheme of this type, if there was a way of making it compulsory, I would be welcoming of that, of course. But moving now in terms of the level of awards, one thing that I take from this bill and the underpinning policy is that it's meant to be a national, a collective redress scheme. So it's moving away from individual impact to systemic failure. So effectively, it's looking at the nature of the abuse and the physical acts themselves, rather than necessarily the individual psychological impact. By contrast, civil litigation is about the individual, the impact on that individual, and often that is lifelong psychiatric impact, which results in a reduction in work capacity and indeed an ability to pay into a pension scheme. So what we have to do is effectively take each individual and look at what the impacts are in terms of their injury and their consequential losses. So in those circumstances, you will appreciate that the level of damages in terms of what we do, which is reparation, trying to put somebody back into the position that they would have been but for the abuse, it can be quite considerable, quite high figures, and the levels of awards proposed are moving away from that individual impact and are simply systemic failures, and it's the description of the acts themselves rather than the psychological consequences. So in terms of the fair and reasonable point, I think that's a very difficult question to answer, and really it has to be balanced between. I think the concept of polluter pays is well recognised. So I suspect that this will be determined by the number of applicants and the description of the abuse, which would determine the tariff award, and in turn what would be a fair and reasonable contribution would be that the polluter pays for their share of the applicants that have made an application through redress.
So I'll go to Mr. Nicol and then to Ms. Doherty again.
Thank you. I think in terms of the point about undercompensation, all I can say is, based on my experience, and I think it's also Kim's, that the level of compensation that is achieved in civil claims is higher than what is being suggested under the scheme. For example, the last sexual abuse case I settled earlier this year, the victim received £160,000, which was predominantly for the injuries, very little built in for any other heads of claim. Now, if the top end of this scheme is 80,000, which I anticipate would cover the worst case scenarios, it seems likely that higher awards are achievable in court. But we recognise that a quick and efficient redress scheme that pays out significant sums is a good thing, because it gives certainty and it gives money maybe slightly quicker than it would be expected to obtain in court. But it's important to understand, as Kim has explained, that every case in a civil court is looked at on its own merits, and there's very seldom two cases, even with broadly similar circumstances, that will attract identical awards of compensation. So it's impossible to come up with alternative figures for the redress scheme other than to suggest that they are less than would be achieved in court. In terms of the fair and reasonable contribution, all I can really say to that is that clients often want to see the offender pay. This is one of the disadvantages of a criminal injuries compensation scheme, where it's simply a tariff-based scheme that pays out without any contribution from the offender. So I think the answer to that is, the higher the contribution towards the total settlement comes from the contributor, the better. I don't have any answers as to what percentage that should be, but certainly I think survivors of abuse would like to see that as high as possible. Thank you.
I'll go to Ms Doherty, and then another question from Jamie Green.
Okay, so I think there were three specific questions raised. So the first one was making them contribute rather than them volunteering to contribute. As we said in the faculty response to the consultation, one problem is that an organisation should be able to rely on any legal defence that they have, and there could be an engagement of Article 1 protocol rights if an entity is made to contribute when there's no insufficient evidence to establish that they've done anything wrong. So that's the problem with saying, well, we can just make people contribute, unless there's good evidence that they have committed these abuses or were responsible for these abuses being committed. There's a difficulty in making an organisation pay, which I think is why the hope was that they would voluntarily accept responsibility. And as I said, some of them may well do that. There's evidence that that's happened elsewhere. Or if there is evidence through litigations that events have taken place for which an organisation is responsible, then that's another thing that would be useful then to establish that they really should be paying. The second point was in relation to undercompensation. I would just concur with what's been said already. Potentially what can be achieved in litigation is far higher than the sums set out in the redress scheme. But obviously litigation involves a lot of hurdles, but potentially there would be higher awards in some cases. The issue about what would be a fair and reasonable contribution, the faculty's response has been that really that level of contribution is a matter of policy. I agree with what's been said, that from the survivor's point of view, there would probably be satisfaction in knowing that there's been a decent contribution from the organisation, but what percentage, what proportion that should be, I'm afraid I think that's a matter of policy, and I wouldn't want to comment on it. Thank you.
Thank you. Mr. Green, thanks.
Thank you, Convener. I do appreciate it. It's been a very interesting opening few moments already. Just to put things into context, though, and I think it's important that the committee are aware of the role that the organisations presenting evidence have in this. Can I ask how personal injury lawyers who are represented today participate in these schemes? Are they paid on a fee basis? Do they receive normally a percentage of the award? And are those fees paid by the claimant or in relation to, are they bundled in with awards, for example? And I think the reason that's important, I'm keen to understand what advantage there is to a claimant pursuing a redress scheme, which is deemed to be more simple and easy to pursue than going down a legal avenue. And isn't it the case that actually a claimant could pursue both a legal avenue and participate in the redress scheme, but only have to make the choice to which avenue they would like to complete until they have sight of the potential value of the award? So it's not an upfront choice. The choice is made at the end of the process, is how I'm led to believe it works.
Thank you. I'll go to Miss Leslie. If not everybody has to answer these questions, but if you do have something to say, I will bring the panel members in, but I'll go first to Miss Leslie.
Thank you, Mr. Green. That's a very interesting question. And again, I want to pick up in relation to the process that I see is set out. So you're absolutely correct to say that the only time there is really an election requirement is on the point where the applicant has to sign a waiver. But the way that it is set out in the bill is that the applicant can go to Redress Scotland having not consulted a solicitor at that point. And it's only at the point that they receive an award, so for an example, it's £40,000. So they've got a £40,000 award, and they're then strongly encouraged to seek legal advice. At that stage, they have 12 weeks. So the clock is ticking because the validity of that offer is 12 weeks. In special circumstances, and at the discretion of the panel, that period can be extended. Now, my view is that should be mandatory. So if somebody it's too short a window for someone to make that critical decision, and it will not work in practice. So it's at that point that legal advice is sought. And as I say, in terms of, you have to work out what you're giving up. And at that stage, it's going to be very difficult for a legal advisor because, remember, it's individual impact and it's also viability of a claim. So there's going to be a number of factors that have to be weighed in the balance at that point by a legal advisor in order to advise the client comprehensively about what they would be giving up for all time coming if they were to sign that waiver. So it's absolutely critical that they get legal advice. I would suggest that the process should be that on receipt of an application, before an award is made, strong encouragement is to take legal advice. And I think that we have to build in the safeguard in this bill that if a request for a pause is made, then that is given. And I'm going to draw an analogy with the Criminal Injuries Compensation Authority, which is obviously a scheme to compensate innocent victims of crimes of violence that we have at present, which is what happens often in practice is that an application is put in and paused or stayed immediately without any administrative burden, without any payment being made. And the civil case is considered and concluded, and that is only there effectively to preserve the option in case the civil claim does not result in any financial redress to the claimant. So in terms of how things are funded, there's a variety of different ways in which things are funded, and it would be the same for any kind of litigation. But no win, no fee is operated in this field.
Mr. Nicholl and then Ms. Doherty.
Thank you. In terms of funding arrangements, there are three main ways that a civil claim would be funded, either through a success fee agreement, where the solicitor plays a no-win, no-fee arrangement and does charge a percentage of the recovered damages as their success fee. They can be pursued under legal aid, or they can be pursued with the client paying privately. Now, my personal experience is that they're predominantly pursued on success fee agreements. I don't do terribly much legal aid, but I have dealt with these cases under legal aid as well. Success fee agreements are a relatively new concept. The legislation came in obviously earlier this year to allow solicitors to operate on a damages basis. And I think they're working quite well and are improving access to justice. But I think a very important point was made by Kim, that the possibility of pausing an application to Redress Scotland only arises prior to an award being offered. And it's very much the Law Society's view that the ability to apply for a pause should subsist throughout the whole application process, even when an offer has been made, because that would give the survivor the opportunity to put things on hold and give them sufficient time to investigate the prospects of a civil claim and determine whether it's in their best interests to raise that or persist with it. It will take a lot longer than 12 weeks to properly investigate a civil claim, and if the applicant is only being encouraged to go to a solicitor at the time the award is offered, there is simply insufficient time to let the lawyer do their job properly. A further point I would make here is I would respectfully suggest that the guidance that is issued at the outset encourages applicants to seek legal advice from day one before they even put their application in, because we're dealing with vulnerable individuals who may have no idea how best to present their application. It could prejudice their ability to get the appropriate level of redress, and if they are encouraged to go to a solicitor at the outset, then they'll be given advice about all the options and how best to present their application.
Thank you. I'll move to Ms Doherty, and then I'll move to a new question from Mr Johnson.
I don't have anything to add to what the others have said in response to that. Thank you.
Thank you. Mr Johnson?
Thank you. So some of the issues that I'm wanting to ask have been touched upon in the previous answers, but I think it's important to provide some clarity and detail, and that's specifically around the evidential requirements and also in terms of the assessment criteria set out in this bill. But if I can ask about the first question, so when it comes to the evidence required, the simplified application simply just requires documentary evidence that individuals were in residential care and a statement of abuse suffered. So the first question I have is, we heard last week on the basis of the experience of the Irish scheme, that's not always straightforward in terms of providing the documentary evidence of people having been a resident. And then in terms of the individual assessment, there really isn't anything particularly specified on the face of the bill in terms of the evidence that would be required to be submitted. I was just wondering if the panel has concerns on both of those points.
Ms Lethe?
Thank you, Mr Johnston. I think, again, that's an insightful question. And I think one of the things that I have picked up from the bill and the explanatory notes is that For the fixed payment of £10,000, all that is required is a statement from the applicant and a document confirming their residence at the place of harm. But for the assessed payments of £20,000, £40,000 and £80,000, there is an expectation that more evidence will be required. Now, it will be documentary evidence, but one of the things to take from that is that you still have a standard of proof involved in that, and so there are ways in which that can be demonstrated for the individual assessed payment. But the documents that are referred to are familiar documents to me, because those are the very documents that we would be looking to and gather in support of any civil claim. And one thing that I think Tom Shaw's report highlighted quite clearly is that record keeping and record retention is very patchy. And actually, there are bigger issues, not just for the survivor, survivor being able to find records, but if I may, identifying defenders or opponents can equally be difficult, because currently, as the law stands, whilst there should be records being able to identify managers, who often local dignitaries, these records cannot be. I think that there's an issue around documents recovery, and I think that it might be well within the means of some applicants, but by no means all, for them to practically obtain the records. But also, let's look at it from a perspective. This might contain very distressing facts unknown to the applicant, or difficult for the applicant to review. So it would be perfectly acceptable to elect to review again. So I think that there's issues there that are built in, and I think that it raises a bigger issue, which I would want to highlight to the committee, and I would direct them to my Digby Brown response, which is a call for a change in the law in relation to the ability to pursue litigations where the entities are no longer defunct. So an insurance company have been identified and traced, but there's a difficulty in identifying the managers or local dignitaries who actually ran the school, and that's different from England and Wales. And so survivors in Scotland are actually worse off than survivors in England and Wales, because in England and Wales there's been a transfer of liability by statute to another entity that's capable of being pursued. So I think I think that is an access to justice issue that I would want at this stage to bring to the attention of the committee.
That's very helpful. Do either of the other panellists have views on this issue?
If you could put an R in the chat or raise your hand. Mr. Nichols indicated he wants to come in. Thank you.
Yeah, just a brief point. I mean, I echo what Kim said there. I mean, there are often practical difficulties in coming up with even the basic level of evidence. If the whole premise of this bill is to make access to redress easier for the vulnerable survivors, I think we should be thinking about possibility of not even insisting on proof of residence other than by way of possibly an affidavit. So the statement that they're expected to produce could, in the scenario where they cannot come up with documentary evidence to prove residence, simply contain confirmation of the basic requirements that are necessary. And if that is a sworn statement, I would suggest that Redress Scotland could accept that to justify the basic level of payment, just to make life easier for these people in the scenario where all the documentary evidence that's expected isn't available.
Thank you, that's helpful.
Ms Doherty?
Yes, I mean, I agree with what has been said there. There's one thing that in our faculty response we flagged up, and I don't know if anybody else is going to raise it or not, but the bill is silent on the standard of proof. And as Leslie mentioned there, you know, things have to be proved, and we were concerned that there's no mention of that. I mean, in the civil litigation, the standard of proof is balance of probabilities, so it's just more likely than not. Now, in this scheme, it's not envisaged that the organisations criticised will really be entering into the process. So if the evidence is produced and it's all one-sided, it may not be very difficult to satisfy the panel that it's more likely than not that this actually happened. But we are certainly concerned that there's no mention of that at all. And in fact, the way the bill is drafted in section 34, it makes clear that when determining an application, the panel doesn't make a determination on any issue of fault or negligence. Now, that's fine. Yes. But it then goes on to say in subsection 6 that the offer of a redress payment shouldn't be taken as a finding as to whether or not the person in the application acted or failed to act in such a way. So the way it's worded, it suggests that the panel doesn't even have to decide that this happened. And that can't be right, because obviously it has to have happened. They have to be satisfied it's happened, otherwise there shouldn't be a payment at all. So I think that does need to be addressed, because otherwise there's not consistency in the approach. I mean, the panels have to know that they have to at least be satisfied that it happened. And that, of course, that's not saying that the organisation was negligent. That's a different thing, and the panel's not to look at that. But that's something that certainly we have some concerns about at the moment. Thank you.
I'm going to go to Mr Johnson and then to Ms Mackay. Daniel?
Yeah, that sort of neatly prefigures my next question, which is about the criteria for making an award, in particular for an individually based assessment. You know, on my reading of it, the only provision for this in the bill is in section 38, subsection 4, which is where it states that in considering what further sum, if any, is appropriate for the purpose of subsection 1b, the panel must have regard to the nature, severity, frequency and duration of the abuse which the application relates, and may have regard to any other matter it considers relevant. So a little bit similar to the point around the burden of proof. While the bill is clear about eligibility, it says nothing really about how to make an assessment for that final award. Indeed, on that first part, it's really only about the nature of the act itself. It says nothing about the consequence and nothing about whether or not it was avoidable or should have been prevented. And indeed, the sort of part B is very open altogether. I'm just wondering whether or not the panel, and especially Doherty, feels that needs to be improved, either on the face of the bill or whether or not those things should be set up at the very least by regulation rather than simply leaving it up to guidance.
We'll go back to Ms Doherty first.
Yes, I mean, I think section 38.4 at the moment is really giving discretion to the panel. It's setting out in subsection 4A, sets out the nature, severity, frequency and duration of the abuse has to be taken into account and may have regard to any other matter. So it is discretion. Elsewhere in the bill, there's mention to the Scottish Government issuing guidance. I mean, I think that giving the panel discretion about what level of award should be made is fine, but there has to be transparency about how awards are made. So the guidance, if that's what it's to be, would have to give a bit more explanation, I think, about what's expected. It is a bit troubling at the moment that really there's no indication as to how these determinations are to be made. And certainly, from what I've read, the plan is to have guidance available quite soon, and it'll be detailed. But until that's seen, it's really very difficult to take a view on whether the process is going to be robust enough.
Can I just follow up on that? The status of guidance I find troubling with regard to that, because while obviously they have to make the decisions with reference, it doesn't have the same legally binding nature as either those things being on the face of the bill or regulation would have. It is essentially just has to be taken cognizance of rather than followed. Is that sort of the correct understanding of what the sort of the nature of guidance would be in these circumstances?
Ms. Doherty,
Yeah, I suppose it depends how it is described, and until we've actually seen what is suggested, it's difficult to give a clear answer on that. But certainly, it's not unusual to have regulations, for example, for an act to refer to regulations that are made, and I think there is scope in this act for regulations as well. But yes, the effect of the guidance or the regulations should be set out in them. So until we see what's planned, as I say, it's difficult to comment definitively on that. Thank you.
Thank you.
Thanks. I think Mr. Nicholl wants to come in, and if Miss Lizzie could indicate in the chat by putting an R if she'd like to come in on those points too.
Yeah, I think I would take this a stage further and say that it is imperative that regulations are introduced to explain what is required to justify each level of award. Even regulations are not ideal. I would have much preferred to see the explanation for this in the bill itself as primary legislation, because secondary legislation is not necessarily subject to the same level of scrutiny. But it's important to be clear on, so that if there is a discretion exercised, advice can be given to the applicant on whether it is appropriate to seek a review. Guidance, as has been pointed out, is not mandatory, it's just guidance. Legislation imposes an obligation. So I think for that fundamental reason, the clarity on that particular section requires to be included either in the bill or in second legislation, not left to guidance.
Thank you. I'm going to move to questions from Ms. Mackay.
Morning, panel. Yes, I just wanted to ask you about duration of the scheme, which is that it will be open for 5 years, and whether you think that's reasonable, and also the historical cut-off point. In other words, the scheme covers abuse just up till December 2004, and the Child Abuse Inquiry, of course, is examining abuse up to 2014. I wonder if you could just make comment on the time constraints put on the scheme, and whether you think it's reasonable. If I could go to Ms. Doherty first, please.
Yes, I mean, the duration of the scheme, 5 years, our faculty response to that has been, well, it seems a reasonable amount of time for people to know about the scheme and apply to it. But I've read the Association of Personal Injury Lawyers response, and I appreciate that their view is that that isn't sufficient time, but I think I'll let Kim Leslie speak to that. In relation to the historical cut-off, again, in the faculty response to the consultation, I think it was, we thought that the time picked seems rather arbitrary. But, you know, if there has to be a date, then we could see that there was some justification given for the date picked. But equally, I can see that a later date would be could easily be picked also. Thank you.
Thank you.
Ms. Leslie?
Thank you. So yes, in our response, we believe that the inception of the scheme would be equally justified as a date. The one thing I would point out is that in the bill it says abuse occurred, and we, I believe, in our response have said commence, because what you don't want is a situation where abuse is a course of conduct and it extends beyond the date provided in the bill. I think that 5 years is too short, but I think there's a more of a policy issue, which is what we're trying to avoid at all costs is a sense of going, gone. So in a situation where somebody has a live and ongoing civil litigation, what the sunset provision does is that it will effectively be like a guillotine, and what we don't want is applicants or claimants coming under that pressure of time. So what we were advocating for is that any timelessly made application should be honoured, but the applicant would be allowed to conclude their civil litigation before a determination is made in relation to their application to redress.
Thank you. Mr. Nicholl?
I'm not entirely sure why it's felt necessary. One way around that is for the bill to provide for a review of the redress scheme after a set period of time, for example, 3 or 4 years, determine whether it's appropriate to continue the scheme beyond the 5 years. That would be one option, and it's been done in other areas of law, and give everyone the opportunity to see how effective it is, if it's working, and if appropriate, continue it. And I would just echo what Kim has said in terms of the cut-off date, 2004.
Okay, thank you, convener.
Thank you, Ms. Mackay. I'm going to move to questions from Ross Greer and Kenneth Gibsons in the area of next of kin procedure. I'll move first to Mr. Greer.
Thank you, convener. On one specific point around next of kin procedure, I'd like to get the panel's views around the provisions for cohabitants. So cohabitants can make an application for the £10,000 compensation if they have lived with the abuse survivor for at least 6 months. In that situation, they would come before any spouse or civil partner the survivor may have had. There's no length of residency requirement, cohabitation length requirement for them to come above the children of a survivor. Now, officials explained this to us on the basis that it was simply in line with other areas of legislation where there's no length of time, no residency requirement for a cohabitant to have that status. They simply need to have been living with the survivor, or in this case, the survivor, as if they were married. There's potentially some concern. We're talking about a very vulnerable group of individuals there. For them to come before a spouse, there's a minimum period of 6 months. They could, it appears, literally have lived with the survivor for a matter of days before the survivor passed away, for them to be eligible ahead of that survivor's children. I'd be interested in the panel's thoughts on whether or not any kind of equivalent length of residency, length of cohabitation requirement would be appropriate in the case where it's about prioritising between cohabitants and children of a survivor, or whether lacking that requirement and being consistent with other areas of legislation is an appropriate path to take. I wonder if we could maybe start with Ms Doherty on that.
Yes, this is something that we raised in our faculty response, actually, to the bill, because we noted that a cohabitant of 6 months plus is able to apply rather than the spouse, but there was no qualifying period in relation to the issue about a cohabitant where there are children, and we identified that that was an anomaly, and therefore we suggested a similar period of 6 months cohabitation should apply before a cohabitant can be the specified next of kin in preference to the deceased children. So that's our view on that. Thank you.
Thank you.
Do Ms Nicholl or Mr Nicholl or Ms Lacey want to come in on that? Not seeing that. We move back to Mr Green and then I'll come to Mr Gibson.
Thanks, Convener. Yeah, my second question very much touches on the area that we've just been discussing around evidence requirements. It's not at all clear, and this goes to Mr McNichol's point of what is actually in the legislation and what's for guidance. It's not clear what level of evidence next of kin would have to provide. So clearly they would have to provide evidence that the survivor had lived in a particular setting. Beyond that, there seems to be a suggestion that, like, the guidance will probably say that the next of kin would have to provide evidence that before they had passed away, the survivor had themselves stated somehow that they were a survivor of abuse. Going back to that wider discussion about what should or should not actually be in the legislation, I'd be interested in the panel's view, starting with Mr McNicholl, what would be an appropriate level of evidence for next of kin to have to provide for them to become eligible for this payment?
Kin payments.
Sorry, your microphone wasn't. You could just start again.
All right. No, I think in terms of next of kin payments, my reading of the bill is that there's effectively going to be, if they can prove that they're next of kin, the next of kin payment is a payment of the relevant share of the fixed rate. So they just have to prove that they are next of kin and that the applicant would have been entitled to a fixed rate payment. I don't think it's any more complicated than that. I'm not entirely sure there would be any requirement to produce any additional evidence beyond those two things. To keep it simple, that would be appropriate.
I'm hoping to see
understood.
If Miss Leslie or Miss Doherty want to come in on that point. No, I'll move to questions from Mr Gibson. Your mic's, Kenny, your mic's still off. That's you.
Yeah, okay. That's broadcasting, not me. Good morning, convener and panel. Thank you very much. A number of the things I would like to ask, of course, have been touched on, which is an issue with a committee of this size. But just following on from next of kin procedure, the survivor of abuse must have died on or after 17th of November 2016. So I'm just wondering whether Mr Nicholl, for example, believes that that's an appropriate date, or should there even be a date?
Mr Nicholl?
We don't have particularly strong views. Sorry. We don't. I don't think we have any particular strong views on this. I think Kim is probably in a better position on behalf of APOL to give an opinion on that particular issue.
Okay, Ms Leslie?
Yes, in relation to the next of kin payments, I would have obviously advocate the more inclusive it can be, the better, because if I can give the committee this, we have already had two clients die before the processes have been able to be concluded or even really commenced. So there's the tragedy of all of this is that there are a number of people who've just not made it to this time, and so I think it's a great thing. It's a really welcome part of this bill that the next of kin are going to be recognised. So I think the more inclusive it can be, the better. It's a matter of policy which date it is, if there has to be a date at all, but that's really a matter of policy for.
Okay, thanks. Now, one of the issues that I've been concerned about in this bill is the differential, the leap, if you like, between the amount of evidence you have to provide for the £10,000 fixed payment and then on to £20,000. As we know, it's just a declaration for the £10,000 payment, but when we actually go up to £20,000, there seems to be a significant jump, and other colleagues have kind of touched on the kind of standard of proof and evidence, but I'm just wondering whether colleagues on the panel believe that there should be a substantial revision. I know that Daniel Johnson was kind of probing on this as well. I mean, I'd really like to get more information from people on how they would like to see, if they would like to see a substantial revision in this area, and how we can ensure that when we look at evidence, we have a kind of level playing field. Because it seems to me that different panels may assess different levels of evidence differently unless it's spelled out more on the face of the bill than in perhaps in regulation and guidance, which of course we've touched on previously. So I don't know who would like to go first on that. Maybe Ms. Leslie again.
So again, my reading of the bill and the explanatory notes is that you're absolutely right. For a £10,000, it is simply a declaration, and to get that leap to the individually assessed payment, documentary evidence is going to have to be produced. Now, what is noted as being able to be used might be a statement to the Scottish Child Abuse Inquiry, although currently under the General Reporting Restrictions Order, those statements ought not to be passed to the hands of a third party. So, previous disclosures to police might be used, social work records, medical records, but part of this is to recognise that the silencing effect is that often there will be no record of this in medical records. The social work records may not contain any description of abuse because they were written at a time when the person wasn't speaking out. So there will be an issue with documentary production sufficient to prove abuse, and it's really again a matter of policy whether that is going to be satisfied. But what we have to pin is for an individually assessed payment, it's made very clear that the panel cannot be satisfied on declaration alone. There has to be some other form of proof. That's a big leap.
Well, it is a big leap. I mean, when we think about from 10 to 20,000, it's not a particularly huge increase in additional funding, but the evidential requirement seems to me to be out of all proportion to the additional funds that may be awarded to the individual claimant, particularly for the stress that they would have to go through in trying to actually claim that. And of course, whereas the £10,000 payment, you've 100% likelihood of getting that, whereas evidentially you may or may not, and that of course could weigh on whether or not people want to go forward. So I'm keen to hear what Ms. Doherty has to say about that also, convener.
Thank you. I think our view was that it was reasonable to expect more evidence for something above the basic payment, and that could be from a number of different sources. In our response to the consultation, when we were asked what type of evidence might be suitable, various ones were listed, and we thought that they would be potentially suitable. So an existing written statement from another source, oral testimony, a short written description or a more detailed written description, or documentary evidence of the impact of the abuse. So that could be from medical records or a medical assessment, or there could be supporting evidence from a third party. So I think there are a number of different possible sources of evidence. And given that the individual payment can go up to £80,000, I think it is reasonable that there's more than just a declaration that's required. And that's certainly the view that we took about it.
And these payments are obviously fixed at 20, 40 and 80,000. So how do we ensure that award panels are looking at that consistently across the board? In other words, one person might have got £40,000 from one panel, but they might get 20 or 80 from another for the same level of abuse. I mean, is that how can we try and narrow, if you like, the margin of error in terms of awards, so that we don't have a situation whereby, you know, people have this kind of almost a postcode lottery, if you want to put it that way, in terms of what's being awarded?
Absolutely, and I think we've touched on this already, in that there has to be transparency, there has to be consistency, which is why there will need to be proper guidance, whether that's in regulations or in guidance, which is what's suggested at the moment, about the criteria to meet the different levels. Now, at the moment, it's discretionary because it just says that Section 38(4) what has to be taken into account, but there'll need to be more sort of examples of things, so that there is consistency, and I think that's going to be the major issue, to try to get consistency for the levels of these awards.
And finally, Mr. Nicholl, would there be a hierarchy of abuse in terms of, for example, physical, sexual, emotional? How would we go about having that kind of consistency in your view?
Well, I think it's very important that what has to be produced is not prescriptive, because, as Ms. Doherty has confirmed, every case will be different. Every case will have its own evidential basis, and some evidence might exist in one case that will never exist in another. The things that have to be produced are evidence of nature, severity, frequency and duration. So I don't think it's difficult to imagine a situation where the nature of the abuse is horrific, frequent and lasts over an extremely long period of time would be at the top end of the scale, and the opposite would be true, that if we're dealing with relatively minor, I'm cautious about using that phrase, abuse over a short period of time, you would expect the award, the individual payment award, to be at the lower end of the scale. Now, I suspect the panel who is considering these applications will, over a period of time, build up precedent. Whether that precedent can in any way be published to give guidance as to the reasoning behind their decisions is something that we maybe have to be looked at, but certainly it would be available within Redress Scotland, so that they can take consistent approaches, just like a court would do looking at precedent in personal injury cases. But I think it is absolutely fundamental, going back to the point that was made before, that there is clear indications and regulations as to what is expected, and what the individual assessment has to consist of, to allow applicants and any advisor involved to know whether the award that is made is appropriate or whether the award requires to be reviewed.
And Mr. Nicholl, is there capacity in our system to deal with the huge number of cases that we expect to receive over the next few years?
Well, I think the beauty of this is keeping it simple, so that the anticipated volume of cases can be processed quickly and efficiently. So, not expecting the vulnerable survivor to have to produce massive amounts of evidence, keeping it simple and simply basic levels of evidence to be produced should, I would have thought, allow Redress Scotland to process significant numbers of applications quickly. That would certainly be the hope and expectation.
Thank you for that. Thank you, Convener.
Thank you. We move to questions from Ms Wishart. Hopefully, I know she's had connection problems, that's issues in the Parliament now. Good morning.
Good morning, convener and colleagues and panel. I'm very sorry for the problems I've had, but I'm here now and hopefully you can hear and see me. I wanted to ask the panel if they could expand on the written evidence about applicants with convictions for serious criminal offences. And I wonder if you could give a bit more, from what's in the written evidence, and also whether you think it's appropriate that it should be, a decision on that should be left to the discretion of Redress Scotland panels.
Can we go to Ms Leslie first?
Thank you, Ms Bishop. Yes, I have to say that I do believe that for the credibility of the scheme, there had to be some retention of previous convictions being considered. But we all know that the correlation between adverse childhood experiences and consequential offending behaviour, and it is an issue in the existing criminal injuries compensation authority. So when I'm doing my analysis, I obviously look at current time at all potential lines of redress, and for many criminal injuries, because there's a blanket ban under the 2012 scheme. So I think that we need to have some discretion. That will mean that there might be inconsistent decision making. I think we have to, the more discretion there is, the more risk there is for inconsistency. But I do believe that it reflects the reality that there are some individuals who have offended that still ought to receive a payment. And it goes through the criteria to say, well, period of rehabilitation. So again, it does mean that each case will have to be looked at on in its own facts and circumstances. But I do think discretion here in this particular area is necessary, because there may, under the CICA scheme, they're out, and I see that as sometimes not always the right decision.
I'm looking to the other panel members to see if they want to contribute to that question. Ms Reckle, are you want to come in?
Yeah. Just one point I would make, I think it just follows on from what Ms Leslie has said there, that my experience, survivors of abuse will quite often find themselves the wrong side of the law because of the consequences of what they have been exposed to. And I think it's extremely important that they are not barred from making an application in a situation where the conviction has resulted from the abuse that they were subjected to. So taking that to its logical conclusion, I think it should always be open to a survivor to produce evidence that can effectively link any conviction or any wrongdoing to the abuse that they have suffered. And that is something that should be taken into account by any panel determining these applications.
Ms Doherty?
That we addressed in our response, and the faculty position remains that a criminal conviction should not be a bar to an application, and the purpose of the scheme is to acknowledge and provide tangible recognition of harm as a result of historical child abuse. Person's character or conduct after the abuse should have no bearing on any redress payment, and so it should never be in the public interest to preclude an applicant from receiving a redress payment on the basis of a conviction. And in our view, that would be consistent with the approach for proposed non-financial measures as well, which would always be potentially available to applicants, even applicants with serious convictions. So although the present bill allows a discretion to exclude these applicants, in our view, that shouldn't be there. There's no need for such a public interest exemption to be possible.
I have a couple of members with supplementaries in this area, Ms Bishop, but do you want another question?
No, that's fine. I'll let other colleagues come in. Thank you.
So I'll go to Mr Green and then to Mr Johnson.
Thank you, Convener. It's just following on from this. It's perhaps one of the more controversial elements of the legislation. I think, I wonder if the panel can see the conundrum that we face, and that's that the public will be obviously scrutinising the bill that we pass as legislators, and there will be concern that somebody, for example, who had been convicted of a serious sexual assault or on a child, for example, is then able to participate in a scheme and receive £80,000 in redress money from a publicly operated scheme themselves, and may see that as either unfair or indeed immoral in some senses. How do you think we should address that?
Okay, can we have Mr Johnson's question as well, and then I'll go back to the panel.
Yes, thank you. I just really wanted to, both on this and Kenny Gibson's line of questioning, there are questions around what the panels will take into consideration and how they make the deliberations. And I know that the both in terms of the awards and indeed reviews, the panels are only required to provide a summary to the applicant and to ministers. I just wonder if the panel feel that actually there should be more substantial records kept and a record of the evidence that was considered, and that whether that should be a requirement on the face of the bill.
Okay, I'll go back to the panel in turn. I'll go to Ms Leslie first.
In terms of the previous convictions, I'm picking up from the first questioner. So in April's response, we did agree that for credibility in the scheme, that there ought to be certain applicants who were barred, but we welcome this discretion so that each case can be looked on on its own facts and circumstances, because I do accept that there may be some crimes that are so serious and violent in its nature that there may be an argument that in those circumstances, to retain credibility in the scheme, that applicant would be barred. But again, I think there is a safeguard built in so that the consideration can be given by the panel so that everybody can make an application and they can put their own facts and circumstances. But again, for consistency of decision making, these types of discretion areas may well benefit from very prescriptive guidance, or indeed for a policy decision whether these indeed need to go on to a regulation. Forgive me, what was the second question?
Second question.
It was about record keeping.
Record keeping, thank
and
you.
Details of decision making.
Grateful to you. So again, yes, I think that is important. So I'm going to draw the analogy with the Criminal Injuries Compensation Authority, and so at present, an applicant to the Criminal Injuries Compensation Authority will receive an award, effective, or an offer of an award. At that point, unless they have a legal advisor who's aware of a certain case of Leatherhead, they might not necessarily know that they can request all the documentation that panel or the decision maker used in making that decision. So for me, I think that we have to see the workings. We have to see, in order for us to advise as to whether there's a potential review, we have to see the workings as to why the panel came to that conclusion. And so we can scrutinise it. And ultimately, this is potentially one for judicial review. Of course, we need to see what the basis of the decision.
Okay, I'll move to Ms Doherty and then to Mr Nicholl.
In relation to the previous conviction, I mean, the view taken by faculty was that this scheme is intended to address the harm to children, and therefore considering what an adult has done by means of a conviction is not something that should be taken into account. As has already been mentioned, the fact that something happened to a child may influence their behaviour as an adult. But to keep it simple, basically, the view of faculty was that such applicants should be treated like all others. And I appreciate that what's happened now is that there's a public interest exception allowed, but as I said, the faculty's response is that that's not needed. In relation to the second question and evidence being kept, and so that it's clear the basis on which the decision is being made, clearly the panel will have to give reasons for its decision, because there is the potential for a review and then the potential for a judicial review. And so all decisions will have to give reasons, so it's clear to somebody else why that decision has been made. In relation to the documentation relied upon, that doesn't seem to be a complication, because the applicant will have submitted the documentation, so should know what documentation is being relied upon. But the view that the panel has taken of that documentation and the reasons for its decision, yes, should be set out in a decision. Thank you.
Mr. Nicholl?
The point I would add is the record keeping should be detailed to the extent that it record clearly what the panel took into account under 38 subsection 4, because that's the evidence that the applicant has been obliged to submit, and it needs to be clear from the record keeping what weight was put on that evidence, what factors were taken into account, and what the basis of the decision was having regard to those requirements, so that advice can be given as to whether the decision is reasonable or should be challenged.
Thank you. I think we now have a final question in this session from Dr. Allen.
Thank you very much, Convener. We've talked a fair bit about financial redress, and I just wondered if I could shift on to talking about non-financial means of redress, and just get a view from the panel as to what they consider to be effective, particularly in terms of an apology, and whether they feel the bill covers that adequately.
Okay, I think we'll go to Ms. Leslie first for that one.
Again, something that I touched on earlier, which is that I think it would be wrong to assume that redress is the only way in which these non-financial redresses can be obtained, because of course that can feature and has featured. I think that's really for a survivor to speak upon, because I think it means different things to different people, and I think that an apology or an acknowledgement is very important, but how that will manifest will really be dependent on what the survivors will say would be meaningful to them. But again, from experience, I know that a letter of apology, I think, has been touched upon. Meetings with various chief executives or safeguarding officers we've brokered. So it's difficult to see that there's going to be something that will cover everybody's particular individual needs, and one of the things that I think is to be commended by this bill is the inclusion of non-financial redress for everyone, and I think that will be a very progressive step for some.
Mr. Nicholl, do you want to in on that one too?
Yeah, I think it's absolutely right to say that what constitutes non-financial redress will vary significantly from case to case, and it just has to be looked at, provided the panel or Redress Scotland as a whole has the ability to look at the evidence that's provided by the applicant as to what they are seeking by way of non-financial redress, and can take that into account. Then I would hope that the scheme will meet their needs in that regard. One element of, if it can be included in non-financial redress because it's not part of the award, is to ensure that legal costs are adequately covered. We haven't quite touched on that, I don't think, this morning, but I have to say, when I read the bill, sections 88 to 90, in my view, just create a whole unnecessary layer of bureaucracy in requiring assessment of legal costs to be made. And one suggestion I was going to make was that to ensure that legal costs are properly dealt with and are certain, everybody knows where they stand with them, that a set scale is introduced, which effectively sets out the amount dependent on the level of redress that is offered to an applicant. And that would give everybody certainty, and it would allow the legal advisors for these applicants to know that the costs are going to be recovered and the client is able to retain the full level of redress that they are being awarded. So it's just it's food for thought, because I think there's, as I say, 3 pages of this bill that could be cut out if there was simply a set scale of legal costs prescribed for redress applications.
Thank you very much. Can I thank all our panel members this morning, both for your contributions this morning, but also for your submissions to the committee, which will be very helpful in our deliberations. I'm going to suspend very briefly to allow to onboard the new panel, and when I get a nod from the clerks, we'll go straight back into evidence session. Thank you. Thank you very much, everyone, and welcome back to our 4th evidence session on the Redress for Survivors Historical Child Abuse and Care Scotland Bill. Can I welcome to the committee Joanne McMeeking, Head of Improving Care Experiences at Celsius, Judith Robertson, Chair of the Commission on Scottish Human Rights Commission, Fiona Clark, Chair of Historical Abuse Practice Network, Social Work Scotland, and Programme Manager at Aberdeen City Council, and Janine Rennie, Chief Executive of Wellbeing Scotland. I invite the witnesses to briefly introduce themselves, and we will then move to questions. I'm going to bring in first Ms. Clark. Sorry, Ms. McMeeking. Sorry, broadcasting.
Hi, I'm Joanne McMeeking, Head of Improving Care Experiences at the Centre for Excellence, based at the University of Strathclyde. fine.
Thank you. Ms Robertson?
Good morning. I don't appear to have my camera on screen. I'm not sure why, but I'm Judith Robertson, the Chair of the Scottish Human Rights Commission.
Oh, thanks. Ms Clark?
Good morning, convener and panel. I'm Gaynor Clark. I am the Chair for Social Work Scotland Historic Abuse Practice Network.
And Ms Rainey?
Good morning, I'm Janine Rennie, Chief Executive of Wellbeing Scotland, and we run the In-Care Survivors Service Scotland.
Thank you very much. I'm going to move now to questions from the committee, and can I bring it in first, Mr Gray?
Thanks very much, Convener. One of the key areas on which the committee has already heard some evidence is around the waiver, the requirement for survivors who access the redress scheme to waive their rights to also pursue civil justice in regard to their claim. And I think all of the panel make some reference to this in the written evidence they've submitted. But I would just like to give them all the chance, as briefly as possible, to put their views on the waiver on the record this morning.
Thank you. If we move to Ms McMeeking first.
I think it's important to note, first of all, in terms of the waiver, we had the consultation with the Interaction Review Group in partnership with the Scottish Human Rights Council, and that was in 2017, and that was specifically around the frame of the redress scheme. As part of the consultation, we did not specifically ask about the waiver in the consultation. So I think that's an important point for the committee, an important point for myself to note early doors. Our questions were specifically designed in partnership with the review group. So the intention was a high-level initial questions with the first dialogue with survivors specifically on the matter of redress. So there is a descriptive summary as part of that consultation that we carried out. And also just to note that the waiver is a particularly complex area, and you're balancing efforts to secure contributions in a way that works for the scheme and for survivors, but at the same time respecting rights and choice, and it's incredibly challenging.
Thank you. Ms Robertson?
So much of the discussion around the waiver has been focused on incentivising organisations to contribute, and I'm sure will come later in the evidence that clearly the wishes of survivors in the work being done by Celsius, the consultation prior to this, was very clear that really the responsibility of providers to pay or to contribute to the scheme was uppermost in their minds. However, the Commission believes that we need to refocus on the needs of survivors in relation to the waiver and the impacts of it. It basically asks survivors to give up key rights to receive redress, and from our perspective this is not best practice. More than one avenue is often needed to achieve different aspects of the right to effective remedy, and by asking survivors to sign a waiver, they're effectively obviously being asked to give up the right to take a civil route. We, in our submission, really sought to encourage the government to explore an alternative option. We proposed the offsetting option, in that payments received by the redress scheme would be offset against any future potential payment that might come from a civil case, and that discussions should be had around the potential for that. One of the issues with this whole process is the transparency that's around it. We're very much aware that the confidential nature of discussions with commercial bodies and providers, other providers, seek confidentiality, but in fact transparency is the thing that's going to shed the most light on this for everybody involved, Parliament and the people who may or may not benefit from this scheme. So we would be calling for full transparency around those discussions, and for it being very clear in the whole process of both developing this scheme in relation to waiver, should that go ahead, but also in determining the various aspects of the decisions around this scheme, the aspects of fair and meaningful, and the other things that we'll probably come to explore in this process.
Can we go to Ms Clark and then Ms Rainey? Thank you.
Thank you. So the priority for Social Work Scotland is the operation of the scheme itself, the process, and the support available to applicants in relation to the non-financial redress. We are also have an interest in the impact on social work departments, including those responsible for right to access subject access requests. Notwithstanding, in relation to the waiver, for it to operate effectively, Social Work Scotland's of the view it must be clearly and specifically line the period, people and organisations, and instances of abuse for which the survivor is accepting the redress payment. And on that, it is really crucial that survivors have independent legal advice at the stage in order to make a fully informed decision on the waiver. Thank you.
Thank you. Amy?
Yes, there have been many concerns expressed to us by survivors on this particular issue of the waiver. In fact, when we've carried out our own consultations with survivors, that's been the biggest issue for them in terms of the redress bill. In the original consultation that was carried out by the Scottish Government, the question on this particular waiver aspect was not clear to people who were answering the question. I personally went through a lot of the responses, and actually, when you exclude the responses when people didn't understand the question, there were actually 58% of people who were opposed to the waiver. In our own consultation that we carried out with survivors, we carried out a survey and consultation exercises. Only 4% of survivors were in favour of the waiver. And when they were asked if organisations should still be accountable through civil justice, only 2% of people were opposed to that. So the overwhelming view of survivors, and we work obviously with a huge number of survivors, is that they're opposed to the waiver. They actually, a lot of them expressed extreme anger about it and wanting to take quite significant action against the waiver scheme itself. And I totally echo what's been said before. Survivors need to have the appropriate legal advice to be able to make that decision to forgo their civil rights. A lot of survivors have been waiting a number of years, obviously decades, for this redress scheme. And a lot of them will go forward and accept the £10,000 because a lot of them are in extreme poverty. They have high levels of debt. They will think, I need to accept this. And a lot of survivors have said that to us, we will accept it. But essentially they'll accept it and then forgo their rights to potentially much more. And they think that down the line that will have significant impact on their mental health because they've gone ahead and accepted something out of desperation and then not given themselves the opportunity to see if they could have gone further elsewhere. So huge concerns about it, I have to say, from the survivor community.
Mr. Gray?
Thanks very much. Just a quick question and clarification really to Ms McMeekin. In your answer to me, Ms McMeekin, you said that in the consultation you carried out, survivors felt, I can't remember the exact words you used, but the most important thing was that the organisations involved in their abuse contribute to the redress scheme. But Janine Rennie has really, I think, just said that if the consequence of that is the waiver, that actually survivors don't want to accept the idea of the waiver. I mean, just if you could clarify there the point you were making. Do you think the point you were making about the question that was asked, the way in which the consultation was undertaken, or were you suggesting that survivors would accept the waiver if it meant there would be contributions?
Go to Ms McMeekin and then to Mr Neil.
Yes, happy to clarify that. very specific around the national consultation that was carried out in 2017, and there was no specific questions in that consultation specific to the waiver. So I think that was an important note, that there's not any evidence at that point coming through from survivors that would be something that they would be in favour of or something that they would be concerned about. So a point of clarity there. And what I wanted to add was the complexity around waiver. There is a real understanding that survivors need to access justice, and some of that may come with regard to financial compensation, and some of it will also come at a cost if you move into the civil court, in terms of evidence, in terms of what that means in terms of re-traumatising. But at the same time, there is a really tricky balance around civil liberties and the opportunity for survivors to make the right decisions at the right time, have the right information in order that they make informed decisions about whether or not they want to sign a waiver or whether or not they want to move into the civil court or actually pursue it to conclusion. So where I was going was incredibly tricky, very, very complex area, and also a real balance around providers and what they would be contributing to that as well would have to be really teased out.
Thank you.
Thank you. Move to Mr. Neil. Thank you.
Okay, thank you very much indeed, Convener. My first two questions are actually directed to Judith in terms of human rights. And she, in her first answer to Ian, said that the waiver as currently proposed, quote, not best practice. Can I ask, is it only not best practice, or is it actually a breach of human rights conventions? How strong is the view of the Human Rights Commission in relation to the rights of the people who've been abused in terms of the waiver? The provisions in the bill for those people who have been convicted of a serious criminal offence, where Redress Scotland will have discretionary power to refuse a redress payment. From a human rights point of view, what is the view of the Human Rights Commission on that particular provision? And once I get that, I would like to come back to Joanne on something specific as well. Convener, please.
Okay, can we go to Judith Robertson first then?
Thank you. I think our view, we don't think it's a breach of any of the convention rights to offer the waiver. We would have said that in our submission if we thought that. The reason we're saying that we think it isn't good practice is because you're actually taking away one of the avenues, one of the routes to remedy from survivors, and that is not good practice. And we also don't think it's necessary. So therefore, what we're looking for is an alternative. We also do recognise that there is a balance to be struck around the role and the contributions to be made by providers and those who have actually undertaken the abuse. But we do not think that needs to necessarily be done at the cost of sacrificing rights of survivors in the process. I listened to the earlier discussion and I agreed with much of what the panellists were saying about the processes of engaging providers in a meaningful and transparent discussion around that. And for the terms of that discussion to really be open to the light and for survivors themselves to review the terms of those discussions so that they also have some insight into it. In relation to your second question, can I sorry, something distracted me when you asked. Were you asking about in relation to prisoners receiving payments? Yes. People with a criminal conviction.
Yeah.
So again, best practice. Well, basically, from a human rights perspective, nobody should be disbarred from receiving remedy, access to justice for harm done to them. In this context, when they were a child as a result of historic abuse, and so from a very positive human rights perspective, that shouldn't happen. However, we do not think that the provisions in this bill breach the convention rights because they're taken on a case-by-case basis. They enable an application to be made and recognition of the harm to be done, and for that assessment to be made, the discretion for the panel to have that assessment and to make that assessment. So we basically think that in and of itself enables this to be compliant. So I mean that's our view in relation to this. Yeah.
And do you think there's a need for criteria to be laid out in regulations or guidance about when the discretion can or cannot be exercised from a rights point of view?
Certainly providing clarity is always helpful. More clarity is always helpful. I think enabling that case-by-case assessment is also the balance to that. And so some of those criteria could bring that into play.
Okay. And convener, can I ask Joanne, please, specifically about the waiver? I hear in what her and her organisation are saying. I'm assuming that they don't regard the waiver as the best option here. That it would be better to have an offset system whereby any monies received from the redress system could be offset against any successful higher claim in a civil court. And is that, am I interpreting that correctly? Is that the view of her organisation and the people she's dealing with?
What I'm saying is it's an incredibly complex area, and when the consultation happened in 2017, we asked respondents about contributions, but we didn't ask about waivers. I think that's important. I've noted that before in giving evidence. So, for example, with contributions, 94% of survivors who answered that question believed across all of us that Scottish Government, care providers and local authorities should contribute, providing strong views to explain their response. So there was a very, very strong sense from respondents that there should be contributions. We didn't ask specifically about waivers. I was listening into the earlier evidence from the legal reps. I was really interested in some of their views around civil liberties, around civil rights, and also about some of the complexity about this area and the need for very, very significant support for a survivor to make a decision whether or not they were going to sign a waiver or not.
So presumably the kind of overriding consideration here is the need to ensure that contributors don't get off the hook, if I can put it that way, that they, one way or another, are forced to make a contribution.
Yes.
Is that right? Yeah. Right. Okay. Thank you. Yeah.
Is it possible to finish, Mr. Neil?
Yeah. Yes.
In terms of providers making a contribution, we would have to be really clear that they were going to follow through on that. We know that there's a number of organisations across Scotland, different structures, different levels of governance, particularly charitable trusts, etc. So there would have to be real fine detail about each organisation taking that through to conclusion, and that would be an area that we would be looking for Scottish Government to look at in more detail. I know that they're working on some of the detail around conversations with partners, particularly care providers, and it would be very much a view from Celsius that they are able to robustly move in and around that, and also under transition, some of the changes that happen in organisations across Scotland, like any organisation, for example, a board of trustees may change, a CEO may change, staffing may change, culture may change. So what may be agreed at the beginning needs to be concluded and fulfilled at the end.
Yeah, we heard an evidence last week from Ireland about one organisation that allegedly was one of the main guilty parties in abuse, and it's absolutely refused to contribute a penny, and has taken a very robust position in not coming forward to pay any reparations whatsoever. And presumably you're like me, we want to make sure that position doesn't arise in Scotland.
I'm also mindful of the trickiness for care providers. Currently, they will be asking a number of questions to understand the bill, their responsibility in that, what it means for liability, what it means for insurance, what does it potentially mean if they sign up to the scheme, and what does it actually mean if maybe no survivors from their organisation come forward and they've contributed, or they have a number of survivors who come forward, and what will that mean for them financially as well?
Yeah. Okay. Thank you very much.
Those points, Mr. Neil, Ms. Robertson.
Yeah.
Yeah, I just wanted to come back on a couple of those. I suppose from our perspective, Section 12(7) of the bill provides that removal of a scheme contributor from the contributor list does not affect a waiver signed in respect of that contributor. So ultimately, if a provider does not contribute to the scheme, even though they had committed to do that, for example, that would not then remove, that would not then enable the removal of the waiver. So if a survivor signed the waiver in the belief that the organisation responsible for their abuse is going to make a fair and meaningful contribution, and then the organisation doesn't make that contribution, the waiver will still apply. The Commission strongly believes that should the waiver go ahead, and there should be a mechanism in place where organisations who do not make agreed upon contributions cannot benefit from a waiver, if that makes sense. Yeah, so there are ways of strength. If you chose to proceed with the waiver, there are ways of strengthening the current provisions that make them more compliant, I would say, and enable survivors to receive, to balance out those different aspects of the bill.
I have a couple of supplementaries from Jamie Green and Alistair Allen. I'll maybe take those together and then come back to the panel. Mr. Green?
Thank you. I was just waiting on my video to click back on. Can I ask around this idea of the contributors and the cost to them, and I'm only throwing it out there perhaps as devil's advocate. If one of the contributors or a number of them are charitable organisations who are already, for example, suffering financially due to the current climate, but are concerned about the open-ended nature of the potential liability to their organisations and how that may affect their current ability to do good charitable work, notwithstanding the wrongs of the past. How do you think survivors would feel about that if charities were being asked to contribute in a way that would then damage their ability to do that work? And what should we do about organisations which don't currently exist anymore? Should the liability be spread around other contributors, or should that liability be topped up, for example, by the taxpayer to contribute what would have been contributed by an organisation which currently doesn't exist?
Dr. Allen, do you want to come in as well on that point of the amount of money? Reasonable.
Yeah, Ms. Robertson, you raised this question about whether the bill, in your view, should be altered to remove the possibility of organisations benefiting from the waiver if they don't make a fair and reasonable contribution. I just asked the question I asked the last panel, which is, do you have a view about how that fair and reasonable test should be measured or met, and what is fair or reasonable?
Okay. I think that was directed, so go to Ms. Robertson first and then bring another panel in.
I think in relation to Mr. Green's questions, the survivors we've been working with in relation to this process are very aware of the potential impact of existing and operating organisations on the potential provision of their services, and do believe that has to be maybe not factored in, but recognise that that's an issue that has to be balanced and brought into this discussion. So I think that's something that is alive and appropriate conversation, and maybe that comes into that second question from Mr. Allen in relation to what is fair and meaningful. That's been a discussion that's also within the review group that I chair and am part of, that sense of what is fair and meaningful is a very, very live discussion, but I don't think we're in full receipt of all the information around it. And so we're very clear that, that again, it comes back to my point about transparency. I think in order for this conversation to, to be given a bit more substance in some respects, that those discussions and the parameters around what fair and meaningful looks like are fully aired and fully explored and are part of this conversation in the Parliament as the bill goes through. So we're very keen to see more elaboration of that, for that to be understood and interrogated fully by survivors themselves, and we will be doing the same and supporting that process. Yeah.
Thank you. I'm looking to go to Ms McMeeking. If Ms Clark and Ms Rennie want to respond to those questions, if they could put an R in the chat. Yeah, I see Ms Rennie. Thank you. If Ms Clark could put an R in the chat, and we'll go to Ms McMeeking. Thank you.
Yeah, I think the concern for has been whether or not that is going to make things particularly fragile for particular organisations if they're having to fund elements of the redress scheme. And that has certainly been something that has come through, and that echoes what Judith has been saying as well.
Okay, Ms Rennie? Sorry, missed the start of that. Could people just pause a wee before, because the microphone's taking a little while to click in. Sorry, Ms Rennie, please start again.
Sorry, yeah. I really take on board what everybody's saying about the organisations that have gone on to carry on to do good work, but it has to be balanced against the views of the survivors. For many of the survivors, they've gone through many years of trying to engage with those organisations. Some of them have gone through restorative justice processes, which they found really lacking with those organisations. And others have gone through very combative legal processes with those organisations' insurance companies, where they were appallingly treated. So survivors are not of the view that any organisation should be able to be sort of paying less to the scheme. We also have found that in the work that we've done, a lot of the organisations who perpetrated most abuse, in other words, the largest number of survivors for those organisations, were those charities. And also a lot of those organisations are the ones where when survivors try to access records, the records no longer exist. So survivors' views are that really there should be an equitable process across anyone paying into the scheme. And they are of the view that people should pay into the scheme, but again, not for the purpose of waiver, but from the point of view of the abuse that was perpetrated over decades. So it should be a separate issue. It shouldn't be that somebody pays into the scheme, so there should be a waiver in place then. But the organisations all should be treated in the same way that they perpetrated abuse back into history, just the same as any kind of state organisations did. In terms of meaningful contributions, some organisations, obviously, there were hundreds of survivors who were involved and abused. In other organisations, there was maybe one survivor, and that needs to be looked at. And quite rightly, it was pointed out that some of the organisations no longer exist. We found that in a lot of cases, and it's very difficult then when they don't exist for the survivors to take any cases forward. And in that situation, many survivors have mentioned to us that they think it should be the responsibility of whoever placed them in that organisation then to fund any kind of payment in terms of compensation. So there are a number of issues there, and while I totally take on board, and as somebody that runs a charity, I understand how stressful this must be for the charities involved. My ultimate goal is to make this fair and equitable for the survivors.
Thank you. Mr Neil, is that you finished with questions? Not saying that, so I'll move on to questions from Mr Johnson. Thank you.
Thank you, Convener. We know that it's the intention of this scheme to make it straightforward and not burdensome on applicants. However, I think we've already heard this morning that the evidential requirements may not be straightforward in terms of obtaining or demonstrating those things. Likewise, we're obviously very well aware of that accepting any compensation because of the waiver will have significant consequences on that person's subsequent rights to legal redress. So do you think that there is sufficient support being made available to applicants? And indeed, specifically on the legal point, while compensation for legal fees is possible, I'm wondering whether or not the scheme needs to more proactively provide applicants with, at the very least, advocacy and, if not, legal advice in terms of the consequences of accepting any compensation payment. Just wondering if members of the panel have views on that.
We'll go to Ms. Rennie first. Thanks.
Yes, I completely take on board what you're saying in terms of one of the biggest concerns that I had, and I only actually discovered it yesterday, was that legal advice was not being provided as to whether to accept the waiver or not. So, and for me, that's one of the key, it's the most key area for somebody to have legal advice, really. I think it's a moot point, because I don't think there should be a waiver in the first place, but if there was, then survivors should have the access to that legal advice, but also support while they go through that process as well. This whole situation is potentially very re-traumatising for survivors. Even the discussion about it is re-traumatising for survivors. So we need to ensure that the appropriate support is in place. Another concern that I had in terms of support for accessing records, so that it was mentioned in the aspects of the bill that people would have support from the members of the Scottish Government or the panel to access records. I had really serious concerns about that, because one of the important things when accessing your records is access to emotional support. If you access your records and then you read really, really judgmental things said about you as a child, or you find out you had a sibling that you didn't realise existed, it's absolutely key that a survivor has appropriate emotional support to go through that process. And just having somebody to go through the practical or advocacy side of that doesn't take into account the severe trauma that somebody might experience from accessing records and what's within them. So, you know, this is something that my concern about a lot of this is it hasn't been trauma informed. And I've heard a lot of the legal arguments and a lot of the legislation, but I'm not hearing a lot about what that actually means for individuals. And I think we can't separate the two out. We need to look at what it would mean to a person to go through this and how it would feel for you. One of the biggest things is really having to provide evidence about the scale and duration of abuse. We have survivors who don't ever want to mention their sexual abuse to anybody, and that even maybe included 5 years before they told us. But we're expecting people to go and tell a panel about the complexity of the abuse they experienced, when often they've not even told family members. So there's a lot more needs to be thought through about this being fully trauma and survivor centred.
Move to Ms. Clark and then to Ms. Robertson.
Thank you. I just want to reiterate what Janine's saying there. You know, from Social Work Scotland's perspective, the bill's not merely transactional or administrative. It's about the non-financial redress that is critical. You know, survivors absolutely have lived their experiences and come back to, you know, they're accessing records which will potentially re-traumatise. You know, at the start of the process, people need to have that emotional, psychological, professional and therapeutic support, you know, on application to the scheme, alongside the independent legal advice, which would be robust and impartial, so that people can make the best decisions. So really there's the emotional impact, but there's also independent legal advice. And also, as Janine said, you know, in relation to the practical support of the application, the bill states that, you know, the team will support the person to apply to get their records, but there's the broader picture of that, where we know that survivors are already coming and asking for their records in preparation for going to seek financial redress through the bill. And there's the aspect of the way records are written. Absolutely, as Janine says, you know, people may not know information about their life. And really it's just that making sure that survivors are fully supported through the whole process. You know, it's absolutely critical that survivors get that emotional, practical support, as well as the legal support.
Thank you.
Thank you.
Thank you, Ms. Robertson, and then Ms. McMeekin.
I think I just want to reiterate what has been said before. I think it's that the whole process needs to strike the right balance between not re-traumatising survivors, but also being a robust enough system that both survivors and the public have confidence in it. So that's a difficult balance to achieve, but I think that everything that's been said by the previous two speakers, it really reiterates the degree of support that survivors will do and will require in order to make applications successfully to the scheme. But also to recognise that redress, effective redress from a human rights perspective, goes beyond financial redress. It goes into those areas of providing support, of ensuring that people's records are available to them. It goes into a whole range of areas beyond redress, which the scheme also makes some provision for. I wanted to touch as well on the issue of legal support. The bill makes some provision for legal support being provided to survivors, and it includes obviously payment to legal advice, to advise whether or not a person should sign a waiver or not sign a waiver. The issue in relation to not we think the importance of access to such legal advice is heightened due to the operation of the waiver, and that they need to be, obviously survivors need to be in a position to make informed decisions about whether this is in their best interests. However, as Janine has raised, Section 89.3 excludes payment of any fees incurred in connection with legal advice and assistance on whether to pursue litigation as an alternative to making an application for a redress payment. And we question how this provision can operate in practice, given a solicitor will be required to fully assess prospects of success and likely damages awards in any litigation in order to advise a person on whether or not to accept a redress payment at a particular level and sign a waiver. So we think that's the same work. We think that, and to say that to exclude that work from happening on the base as part of this process doesn't seem practical. But also we're concerned that in the financial memorandum, which may not be the concern so much of this committee, but a potential cap is put on that at £1,000 plus VAT. We don't think that cap's viable, and that the costs potentially attached to sometimes unpacking what might be quite complex cases. It might be fine if somebody's only seeking the £10,000 payment, but we're going further up the scale in terms of the level of individual assessment. Our assessment would be that cap's too low.
Thank you. Ms McMeeking, and then I'll come back to Mr Johnson.
Just to underline the other evidence that colleagues have been giving, the importance of emotional support is absolutely critical, particularly for survivors who are considering or making a claim. And each survivor is individual. They may have existing support, or they may need additional, or they may need to act advocacy and legal support, and that has to be carried out in a way that's very specific, that's very bespoke, and understands the trauma that a number of survivors have experienced as well. So any construction of a scheme needs to attend to that and pay attention to that, because each survivor is very, very unique in terms of what their needs are. Very specifically around the access to care records, we know a lot of stuff in Scotland about accessing care records, because the Shaw report told us that in 2007, the complications around accessing particularly residential childcare case records and the quality particularly, and some of the effects of survivors reading information about them that they may not have known, that may re-traumatise them, and the need for them to have the right support at the right time is absolutely critical. We also know now, we still have children and young people telling us now, accessing case records is very distressing at times. And even though the information that might be in it is not distressing, it's actually more about understanding what happened in their life and someone was telling a story about them. So that support is really, really important for survivors for this to be a successful scheme.
Thank you, Mr Johnson.
Yes, I just wanted to follow up with Judith Robertson. I noted in your written submission, you go into some detail regarding what the compensation should be for, and it's about essentially the consequences and costs of the original issues that they've had on the individuals. And I guess that I'm interested by that because I think that's different to what is actually set out in the bill. If you read the reasons for the award, and I set this out in the first panel, it's about the original incident, its extent and duration, and there's no mention of the consequences. And I'm just wondering if you can maybe go into a bit more detail, and whether you think the bill needs to be revised and to actually make proper assessment on the face of the bill, or indeed by regulation, in terms of precisely how and for what reasons different levels of compensation should be made, in particular regarding individual assessments.
Daniel, was that for Judith? Yes, thank you.
Yes.
Am I good to go? Yeah, thank you. Yes, I mean, so the definition of compensation that we include here is one that is basically obviously from the human rights framework. I think we think that this bill does broadly comply with that, and that it is to the discretion of governments and providers of these kind of schemes to determine what the parameters would be for payments, and that this broadly fits within that frame. And you've made a point in relation to your second point, Mr. Johnson. Sorry, can you remind me what it was? My memory is going.
Just whether or not there needs to be more I mean, it's really about the consequences of these incidents for survivors, rather than simply compensating for the issues themselves, if that makes sense. Because it just struck me that your written evidence was actually looking at the compensation from a different perspective to the way perhaps it's set out in the bill itself.
I think that's correct. And normally, under a civil justice route, that would be the process that would be applied. Is this kind of principle of compensation as it's determined in our submission? However, we do think that the broad principles that are being applied in this bill are good, are okay, or they're what's the word, admissible or compliant, and so therefore can proceed. Where I think it becomes more it's not so much an issue in relation to that definition, but more of a question that requires to be more robustly tested in this process is around the assessment, the criteria for making one payment versus another payment, and where that then applies in relation to the different scales for payments, as I think that was your second part of the point you were making. And so that for us, at this point in this process, we don't feel that's been fully explained and explored sufficiently to be able to say, for example, whether the payments are the right levels of payment, and B, whether the actual levels themselves meet the particular criteria for each of the different payment levels. We don't think there's enough information in the public domain to determine that. And we would have concerns about the amount being on the face of the bill in the context where that hasn't been able to be fully interrogated by Parliament or by survivors or by anybody with an interest in this process. So we say that in our evidence, and actually we don't think there is enough information currently available to determine whether or not the right levels of payments, the right amounts have been applied.
Thank you. I don't have any further questions unless the other panelists want to contribute on that question.
Thank you, Mr. Johnson. I think Mr. Green wants to come in, and then we'll move to questions from Mr. Gibson. Mr. Green.
Thank you. I just wondered if the panel had any views on some of the timescales and timelines. So, for example, the period of which the abuse occurred that makes any claims valid. So, for example, those who were suffering before the kick-in date. Also from 2004 onwards, there seems to be this perception that because an apology was given and things have changed, everything's okay. So this arbitrary line in the sand from 2004 essentially bars anyone after that. And what else do you think the government could do to help those people who are on either side of that window of opportunity for claiming? I'll maybe start with that question, if that's okay.
Okay, can we go to Ms Rennie first, and then if other panel members could indicate they'd like to come in. Thank you.
Yeah, that's another area we do have concerns about. When we did an analysis of our statistics of clients, we realised that 30% of our clients fell into that category of being after the time period where claims were allowed. So we're really, really concerned that that's going to potentially exclude a large number of people, and we're not sure why that year was put in as the decision. We think it would have been more relevant to maybe sort of when the inquiry was established or something similar to that. I think it's going to cause significant distress, and again, a kind of two-tiered system with survivors, where some will be able to access the scheme and some won't. A bit like the pre-64 situation before we got to this point with the overturning of time bar. I think these things we've seen in our experience of working with survivors, that these kind of two-tiered systems actually create a great deal of distress within the survivor community. And I think something, if it was going to be kept like that, something really significant would have to be put in place for those people. But it really gives me serious concerns that when I saw that cut-off point, I was really concerned about that, because I was very quickly able to go and look at how many people would be excluded.
Happy for anyone else to respond.
Ms Robertson?
So the Commission would share that concern. We think that to set the date of the 1st of December 2004 would mean that almost a generation of children in care would have no right to claim redress for historic abuse, despite the potential for serious breaches of their rights actually taking place. So we believe a more reasonable cut-off date would be 3 years before royal assent was given to the limitation bill in 2017, given that someone bringing a civil case within this timeframe would not have been out with the limitation period of the 1972 Act, and their claim therefore not reasonable, be claimed to be historical. So basically we share Ms Rennie's concern and are proposing a different date.
I'm sure that will be noted in your submission, and the government will be watching with great interest on your proposals. I want to move to a slightly different question, which I don't think we've asked before, and isn't really a technical question, but having read the submission documents, some of the feedback and the comments made, specifically those made to Wellbeing Scotland, were quite eye-opening. The list of bullets that you sent us and some of the anecdotal comments that survivors had given, and you're at the front end dealing with these people on a day-to-day basis, so I think you probably know them better than us. I know from experience my office has already taken quite a few calls on this, given that I'm on the committee that's working on this bill, and we've already had a few accusations of whitewashing, or of cover-ups, of conspiracy, of the government are trying to sweep this under the carpet. They were trying to let these organisations off. This is an easy route out for some of these organisations, etc., etc. You all will have heard some of that feedback, and I think some of that feedback is I can understand where it's coming from. How do we take the public with us on this as we progress this, as MSPs, but also as people who deal with this sort of thing in casework ourselves, and have a huge amount of sympathy for the survivors, but I think we are struggling from the PR point of view, and I want this bill I want us to get it right, but I think we need help to do that. What would your advice be to the committee in that respect?
I'm going to go to Janine for that first. Yes, Ms Rennie, thanks.
I think that was sort of directed at us, just because a lot of the comments from survivors obviously expressed that view as well. And really what that's about is something that we've seen for all of our history, really, where survivors don't trust authority. Quite rightly, they went into a care setting and they were abused, and they felt it was authority that abused them. So they don't even want to go near it. I mean, quite a lot of survivors have expressed to me, they want to go near this panel. I won't be taking part in it. I won't be going anywhere near it. It's a government body and everything. So we're seeing that a lot, and yes, a lot of survivors really feel that, again, I think there was huge mistakes made in the bill from a PR point of view, and even when reading it myself when it came out on a Friday, I was really shocked at some of the content of the bill, so you can imagine how survivors felt after waiting all this time for it. So to get survivors to go with you, you need to listen to them, and first of all, the original consultation, what was taken out of the original consultation, they felt was actually directed at what was wanted by government rather than by what they said. And I think it's really important to be transparent and to be fair in what survivors' views are. Survivors feel it's the same people that are always consulted with and not the wider survivor community. So within our own network of survivors, they've all asked me to write to every MSP in Scotland, which I've done. Had about a handful of responses. And survivors want to actually have a Zoom call with MSPs to tell them how they feel. And we could potentially get a huge number of survivors on that call to actually speak about how they feel. And I think unless you hear from the people who this is actually going to affect, and affect in so many different ways, you can't possibly make an adequate decision. It may be a decision that benefits the public purse, it may be a decision that benefits the organisations. What survivors feel is, and that's why the conspiracy theories are coming out, why is this a bill that doesn't benefit us? And that's what you all need to really sit and consider, like the bill on the face of it. And I've heard all the legal arguments, and I'm just still sitting thinking, where are the voices of survivors? Because it's them that ultimately this is going to affect. Not me personally as the person that runs the service or any of the rest of us. It's the people who will have to go through that process, which in all reality, even for me, that would feel really intimidating to go through that process. So how is that going to feel for the people that it affects? So if you want survivors to come with you, then listen to them.
Okay. And Ms. Rennie, can I just say, I think we understand that sensitivity, and I know every member of the committee will work with the clerks, with the legislative team and the parliamentary team to make sure that anyone who has a voice that wants to be heard will do so in a way that works for them. Not everything has to be done in the way we're holding this session, televised and broadcast. There are many ways we can engage, and I know that we will pursue those. So I'm sure the clerks will speak to you thereafter. And we do want to hear from as many voices as we can. So that's a genuine point of feedback to you. But I think everything you've said has been noted. Thank you so much for your frankness.
Thank you. I'm just looking to see if any of the other panel members want to respond to those points of Mr. Green at this stage. No, I'm not seeing any indication. Thank you. Can we move to questions from Mr. Gibson, please?
Questions, convener.
Thank you. And move to questions from Ms. Wishart.
Thank you, convener. My question, or actually I just really want to take your views, is around applicants with convictions for serious criminal offences, and I know that that's been touched on by Ms. Robertson and Alec Neil's questioning. So I wonder if I could ask Janine Rennie first for her views on that. How in making redress payments to children who were abused and then later convicted of serious criminal offences. If I could take your views on that.
That's you first.
That question. Can you hear me okay?
Yeah.
Yeah. So thank you very much for asking that question. I think it is a really important one, and it's a very difficult one to answer because there's a lot of emotions involved. But all I could say is from our work, we delivered a service in the Scottish Prison Service for a large number of years, and about over 50% of the people that we worked with in the prison had been through the care system, and a large proportion of them had been abused in care. So really, you can draw a correlation between the number of people who were raised in care and had missed opportunities who have ended up falling into the prison system. There's murders mentioned. There have been some people who have actually killed their abuser. So there's kind of huge aspects there in terms of aspects that need to be looked at. And I welcome that this would be looked at on a case by case basis. I think that's the only way we really can look at it. But I totally echo what somebody said in the previous panel in terms of we know the impact of adverse childhood experiences on future incidences of involvement in crime, and that's because every opportunity was taken away from that individual, and often their lives, they suffered abuse and torture for years upon years, and we know the impact of that on people. But I do know that some survivors would potentially take issue if somebody had gone on to abuse children. So we do need to look at it on a case-by-case basis. But in saying that, I also put in an aside to say that in the work that we did with prisons, people did not go on to offend. So essentially somebody could have committed quite a serious crime and then been through a period of rehabilitation and not gone on to commit any further crime. So again, maybe the opportunity wasn't there for rehabilitation and the appropriate support. So we need to look at this in its entirety rather than making just a kind of decision, a blanket decision based on, you know, different criteria of crime.
Thank you, and I wondered what does Ms McMeekin or Ms Clark have any views on that?
Yeah,
evidence indicates that children who are in the care system will pick up offences, particularly for smaller crimes, and will be drawn sort of more attention to after status that would normally be dealt with in a family through parental sanctions, etc. So we welcome the openness of the Scottish Government to consider that, because a number of our children who are looked after and survivors tell us that they have experienced different kind of levels of moving in and around difficult kind of complex situations that are specific to the criminal justice system. I do appreciate the more serious offences have to be considered in much more detail and on a case-by-case basis, and absolutely support that too.
Thank you. Does Ms Clark have any input on that?
Really reiterate what Joanne says, that Social Work Scotland's perspective that they must be taken on a case-by-case basis on the basis of public interest, and the human rights-based approach will be adopted.
Thank you. That's all my questions, Convener. Thank you.
Thank you very much, Ms Bishop. Can we move to questions from Ms Mackay, please?
Thank you, Convener. Yes, I'd like to ask about the abuse covered by the bill, the definition of abuse. It's in the bill, it's sexual, physical and emotional abuse, and abuse which takes the form of neglect. The exclusion of corporal punishment, where it was permitted under enactment of rule of law at the time, isn't included, and nor is abuse by peers. I wonder if I could have your opinion on that, and whether you think those categories of abuse should be included in this bill.
I'll go to Ms McMeekin first. Ms McMeekin, sorry.
Yes, thank you. Thank you. That is a really, really complex area, and my level of hesitation was my thinking head around peer-to-peer, and thinking a little bit about the continuum of abuse that can happen with peer-to-peer as well. I think it would be very, very difficult to bring that into the scope of the bill. And also specifically around corporal punishment, I was thinking about some of the legislation that sits around that, particularly in the 80s, when we were still in positions within Scotland where you could actually give a child the belt within the school. So there was a very kind of clear, formal legislative process that was sitting there. There was instruments that allowed that to happen. So I can then understand why that is not sitting within the scope of the bill.
Thank you, that's helpful. Any other panel member wish to comment?
Yeah, got Ms Robertson and then Ms Rainey. Thank you.
So we're content with the absolute definition as it sits in the bill. and that would be compliant with the international framework in relation to this area. I think the question of corporal punishment is slightly more problematic. It's not so much in relation to the standard of the time, but it may be in relation to the context of the culture within the institution and the effective abuse of corporal punishment within a process, and whether that would then constitute abuse within the system. So I would be concerned about the blanket exclusion of corporal punishment as an issue, rather than including it as something that might be taken into account when looking at the scale of the abuse, if that was established within a cultural setting. So there's definitely a degree there. I take Ms McMeekin's point about the legislative basis for that, or the policy basis for that in the past, and we've moved on from that. But I think the culture within specific settings could undermine the intention potentially of that policy in place, and therefore tip it into something that would be considered abusive.
Yes, thank you.
Ms Rennie?
I think the best way is to give a couple of examples. Within a lot of the care establishments, they kept what they called punishment books. So in a lot of the establishments, there were records of what they deemed to be punishments that took place with children involved in those care homes, and where they were expressed in those books might be seen as evidence as being punishments. In essence, they were quite significant abuse when perpetrated on the individuals. So I think it's a really risky area in terms of what the organisations maybe deem to be corporal punishment, actually we would deem to be abuse. So I think we need to give really serious consideration to that, and maybe what was allowed at the time through legislation shouldn't have been allowed. And again, that was a fault of us as a state, really, in terms of what we were allowed to do to children. So I think that needs to be considered. But really, to give a case study example in terms of peer-to-peer, a lot of the survivors feel that really they were under the care of that care establishment and should have been protected. And I know of a case where somebody was abused by an older child who was abusing quite a lot of the children in that care establishment, and the care establishment did nothing to stop that happening. So I think, where there's been a case of negligence by the organisation in allowing peer-to-peer abuse, then I think that should be considered under the Redress Bill.
Thank you, convener.
I'm looking to the other panel members to see if anyone else wants to comment. I'm not seeing any hands going up. Can we move to Mr. Greer, please?
Thank you, convener. I'd like to ask the panel one specific question, a more general question around next of kin payments. You might have caught this same line of question to the previous panel. I'm interested in your thoughts on the requirements for a cohabitant to apply for the next of kin payment. If the survivor's passed away, has a spouse or a civil partner, the cohabitant has to have been living with them for 6 months prior to the point where they passed away for them to be prioritised ahead of that spouse or civil partner for the payment. There's no 6-month requirement, there's no length of cohabitation requirement for the cohabitant to be prioritised over the survivor's children. And I would be interested in your thoughts as to whether or not there should be some kind of requirement, whether it is a minimum length of time for cohabitation or something else, or whether it should be this automatic presumption that a cohabitant is prioritised over a survivor's children for the purposes of the payment.
We'll move to Ms McMeekin first for that.
My head goes to choice for the survivor in terms of some of the decisions that they make around their next of kin, and the need for that to be ironed out. At the same time, I'm thinking a little bit about the rights of the partner over the children. And where my head is going is that's a very, very technical question, and I would be seeking legal advice on that, because I know that this morning we're talking about it and thinking it through too. I don't have a strong view at this point. I would want to go back and read a little bit more on that in order to provide a much more substantial view. So I'm actually happy to do that and provide the committee with more information in writing. I think it is incredibly tricky. Apologies, that's the post just coming through the door there. I know it's incredibly tricky, and I also do understand the relationship of the survivor with their partner and the depth of that and the importance of that, that they may actually want their partner to stake a claim. And at the same time, I also understand that there will be children who have been in and around for a long, long time and feel a sense of loyalty and also deserving of the money too.
Ms Robertson, did you want to come in on this?
I didn't have a specific, we don't have specific views in relation to these aspects. I think this is really for much more for survivors to views to be reflected in how these decisions are taken. I do have views on next of kin payments, however, but I'm happy to share them afterwards.
Okay, if we can look to Ms Rainey, if she wants to comment on this one.
Again, I would come back to what I've said from the start. Really, the survivor views should inform this, and I think, you know, survivors may have different views, but I think it's really, really important to hear from them. Just as an aside, there was a cut-off point again about when people could, if somebody had passed away, when a next of kin could apply to the scheme. Obviously, we've lost a number of survivors over the years in the service, and I've seen the impact on the family, really, of the abuse that the survivor experienced, and I know that'll be very disappointing for quite a few of them, but I really think this needs to be the survivors' views rather than mine.
Okay, and just an opportunity to Ms Clark, do you want to come in on this point? Thank you. Mr Greer?
Thank you, Convener, and I appreciate that this is both technical and complicated. I take on board the point around this very much having to be an area that's led by survivors. The tricky element of this is something needs to be set out in legislation for the circumstances in which a survivor has not expressed a clear view before they pass away. So what we need to iron out here is exactly what the requirements should be as set out in the legislation. I have a wider question, though, around safeguarding the well-being of survivors. In any situation where a payment, a sum of money is involved, and it's a vulnerable individual, so in this case a survivor who's coming towards the end of their life, there is the potential for exploitation of that individual, and consideration needs to be given as to how are they safeguarded in a situation in which other individuals receiving a substantial payment of £10,000 is dependent on their relationship with that individual and what that's established as being. So I would be interested in the panel's views on how to safeguard the well-being of survivors in that situation at the end of their life, where other individuals in their immediate vicinity would be eligible for a payment, and would there potentially be contested views between those individuals, between cohabitants, children, etc. And maybe start with Ms Robertson, because you'd mentioned that you had some wider views around next of kin payments that it would be great if you wanted to share those now.
Okay, thank you. I'll do that. I suppose that I will come to your specific point after that, if that's okay, that one you've just done there. So the 2 points we wanted to make about next of kin payments was really it's not clear to us why the next of kin payments, next of kin applications should be smaller than those of survivors themselves, if the evidence can be provided to meet the requirements of an individually assessed payment. So that was one basis. I think it's also worth saying we do really welcome the fact of the next of kin payments. We think that's an important aspect of the scheme, and it does also reflect the views of survivors in the original consultation, saying that they felt, although there was diversity of views in the balance, there was a strength of view to say that next of kin payments would be valued and appreciated. We also have concerns about the timescales that have been mooted here. That the survivor must have died on or after the 17th of November 2016 for them to be eligible for the next of kin payment. We think that's extremely tight and very time limited and should be extended. Again, the rationale for enabling next of kin payments is that they should receive some acknowledgement and remedy on behalf of the person who experienced the abuse. By setting the cut-off date as late as is proposed, opportunities for redress for families are really limited, and we think that's too tight. I wanted to come back to the point you were making about vulnerable people. I think this comes down to the question of support, and that again, while a survivor is still alive, they are the uppermost person whose views need to be taken into account, where capacity is such that's possible and can happen. We have some concerns that I think it's section 49 in the scheme provides powers to Redress Scotland to give direction around payment and management for the benefit of the applicant as considered appropriate, but raises questions about applicants who might be vulnerable on risk on receipt of payment, either posing harm to themselves or others, or exposed to exploitation from others. And we're concerned that the bill as it currently drafted places too much discretion with Redress Scotland in assessing the capabilities of a person to manage that payment. And in particular, references within the bill to illness and disability are really concerning. There is a formal legal safeguarding framework in place through the Adults with Incapacity Scotland Act 2000, and we think any restrictions or directions on payment should be made in accordance with that recognised legal procedure, or as such as through the power of attorney or financial guardianship. So we don't think this scheme should set up some different legal basis on which to establish capacity, but we think the schemes we have to do that are sufficient, and that's what should be used in this context. So we've got real concerns about that section of the bill.
Ms Clark, did you want to come in on the safeguarding issues?
No, thank you.
I'm looking to the other panel members at the moment. Ms McMeeking.
To come in on the back of that and to support the current legislation and safeguarding that we have in Scotland currently. So I would be curious about why we were potentially setting up something different or something new around Redress Scotland. So that would be certainly a flag for me, particularly around the strength of power of attorney, guardianship, etc. And there is just a little bit of a curiosity about, because it's a survivor who is acting will not manage it properly. And I think that's a bias that we have to sit with and acknowledge too and challenge.
Mr Greer?
That's all from me, Convener. Thank you.
Thank you very much. Can I have questions for Mr Gray again, please?
Thanks very much, Convener. I wanted to ask the question of Judith Robertson particularly, but Janine Rennie may want to comment as well, and that is about the position of those who were sent to fee-paying schools, not directly by the state but by their parents. And in the written submission, the Commission suggests that the state still had a duty of care to them, and therefore their right to seek redress under the bill shouldn't be excluded. And I just wondered if Ms Robertson could say a little more about that.
Yeah, it's a sensitive issue, and we're very aware of that. And there's a broad diversity of view. The human rights framework would say that where any child had suffered harm, in that kind of setting, they were eligible for financial redress. This scheme excludes that, and from our position, it's okay for the scheme to do that. It can draw parameters, it can make those assessments from a human rights perspective, but that doesn't remove the obligation on the state to make provision for that. Maybe should that be sought in another process, or indeed for the state to support other processes to be set up, maybe by the private institutions themselves, or to ensure that those processes are actually established. So we're not necessarily seeking that the terms of this bill be broadened, we're just recognising that under human rights law, there is an obligation that if a child is harmed in these settings, that provision for redress should be made.
Okay, thank you. That's helpful. I don't know if Ms Rennie has anything to add on that.
Yeah, Ms Rennie.
It's been very clear as an organisation that we think that any situation where a child has suffered abuse should have been included both in the inquiry and any further subsequent processes, simply because it was a failing of our whole society in the years and decades that children experienced abuse. We feel that any establishment where children experienced abuse should be included under any terms, so that we can really learn the lessons as a society about what went wrong. And I don't think, and also those children suffered abuse in a society that accepted that abuse took place, and there was no protection in place for them. So we feel that yes, all establishments where children were abused should be included.
Thank you.
I'm just giving a final call to any members who have outstanding questions at this stage. I think Ms Clark wants to come in on your last point, Ms Agree, so we'll let Ms Clark in.
Absolutely, thank you, Convener. So Social Work Scotland expressed unease about the exclusion of children in the care of medical professionals, children hospitalised and institutionalised, specifically learning disability, mental health, and also boarding schools other than through parental choice. And just really Social Work Scotland's engaged with government on this point and also recognise the complexity and the financial challenges of that, and just really would like that noted.
Thank you very much. Can I bring in Mr Halker-Johnson? I think Ms Robertson wants to come in on that last point first. Sorry, broadcasting, but we'll go to Ms Robertson and then I'll bring in Jamie.
It was just to really add and supplement to that point, we too would like the recognition that often children who were disabled were placed in care, sometimes not under the provision of the state, and that there's a risk under the terms of this scheme that their claims would not be accepted. And I think the discretion from the panel, the Redress Scotland panel, to look at the basis on which people were taken into care institutions, particularly long-term care in hospitals, that's something which needs to be reflected as well.
Thank you very much. Mr Halker-Johnson.
Thank you very much indeed. Apologies, the roadworks have just started outside where I am, so sorry if there's any noise. Most of the questions have been kind of well covered by my colleagues. I did have one question, which is more specific to my region of the Highlands and Islands, and it's whether there are any concerns any of the panellists have in terms of the ability to go through the process, be supported either legally or otherwise for claimants when you live in a rural area, an area that perhaps isn't have access to the same sort of services in other places, whether there are any concerns in that might be raised because of the bill.
Ms Robertson?
Accessibility of provision is a key issue. There'll be a range of different needs of people from right across the country. We're advocating that it should be able to be both a paper-based system and an online system, that people should be able to talk on the phone, they should be able to use whichever instruments they're able to use to actually both give evidence, provide evidence, talk to people who can give them support, advice, and that such costs that are attached to support for survivors across the scheme recognise the different requirements in relation to accessibility and access to the scheme, whether that be people who have issues in relation to communication, they may be deaf or blind, and whatever disability people are experiencing. So the issues of accessibility are paramount. We have these legal requirements to provide support in these ways anyway, but particularly I would say for this scheme, resources need to be applied to those processes in such a way as to enable not just the participation of people from rural areas. Some of these issues will apply to people right across Scotland. So I take your point about whether that be access to lawyers, access to legal support in rural areas. access to the provisions, that really needs to be thought through. It's more of a process and a point than a legal point, but should be recognised.
Yeah, Ms. Meeking.
Ability is really important, not just in terms of the geography, but also how it's tailored so that it is trusting, that it is responsive. It's also flexible support too. I think that's really important. And that's certainly some of our experience of the consultations, that you have to develop and define very, very bespoke consultations in order that survivors are able to engage in lots of different ways that feel comfortable for them and that they trust that their information will actually be listened to and will actually then create a bit of a response. So that's going to be really important in terms of the construction of the scheme, as well as the accessibility and the geographical kind of aspects of that.
Yeah, I'm looking to other members. Ms. Rennie, did you want to come in?
In terms of the wider accessibility, obviously we're in a time of COVID just now and we don't know what we're going to be like next year, so a lot of the engagement may have to be virtual. A lot of people are suffering severe digital exclusion, and one of the other concerns, and we've looked at that in a number of processes through the years, is a lot of people suffer significant mental or physical health issues, so it'd be impossible for them to go to a location. I mean, a lot of people are suffering severe agoraphobia, they don't want to leave the house. And their access to anything is very much restricted because of that. So accessibility is very key, and this is going to have to be considered not only in rural areas, although we accept even the access to support in rural areas is very sporadic, and also the access to transport networks are really sporadic. So all of that needs to be taken into account when considering how people can engage.
I think Ms. Clark wants to come in, Jamie, on that point.
Yeah. Thank you, Convener. Essentially, just back to the priorities for Social Work Scotland is the operation of the scheme itself, the process, and really thinking about that person-centred support that people require, when they're applying to the scheme, the physical, the emotional, psychological, but also making sure that that support is a movable feast and people's needs are absolutely considered, is Social Work Scotland's priority in working with government to develop the bill. Thank you.
Thank you. Jamie, did you have another question? Sorry.
No, I was just going to say thank you. I'm sorry that it was kind of fairly brief, but I think that was extremely helpful and useful.
Thank you. A final question from me, briefly, is something that we haven't covered today, and that's the position on the deduction of prior payments. So it's just really to get the panel's view on the rule. Do you think it's correct that deducting prior payments would mean that survivors would be compensated twice on the same matter if that weren't to happen? Maybe go to Ms. Rennie first for that one, if possible.
I think most of the survivors we've spoken to feel it would be fair that they weren't being compensated twice. So that's why a lot of them are saying there's not really the need for the waiver situation. They feel that they would be quite happy to accept the payment that was most suitable for them, but then to subtract any other payment that they'd had if that made it an easier process.
Thank you. Do any of the other panel members wish to comment on the deduction? Yeah, Ms. Robertson.
I suppose there's an argument. I completely agree with Ms. Rennie in her previous point, and that survivors' views in relation to that, and that would seem to be fair, and that survivors want that to be seen to be fair as well. It would also provide a balance point. There's a lack of balance in the legislation if that offsetting can't be provided around the civil route as well. So it doesn't really make sense. It's slightly illogical to provide it, to make sure it comes off on one side but not off on the other. So yeah.
That's very helpful. Oh, Ms. Meeking, sorry.
Yeah, just very, very quickly to support the Judith and Janine. There's been a very strong sense of fairness from survivors that they don't want payments twice, and a very kind of strong kind of ethical sense of duty, and I think that's important for that to be heard and to be listened to.
Thank you. That's very helpful. Can I thank all our panel members. Oh, Ms Robertson, do you want to say something else? No, it's fine, Ms Robertson, you can come in.
It was just really to make the final point that about disregard in relation to benefits, that this is not income. This is a payment received from the scheme is not income and should not be regarded as income by DWP. I know that is not within the power of the Scottish Parliament to decide, but that we totally support the efforts made by Scottish Government for this to be disregarded as income and for it to be regarded as a reparation for harm done.
As you rightly say, I think those negotiations are ongoing at the moment with Government and Westminster Government on that area. Can I thank everyone for their attendance this morning. It's been really helpful, but not only for your attendance, but your submissions to the committee, which have been very helpful in our deliberations. We will now be moving into private session and ask members to come out of the current video streaming system, and we will meet in Blue Jeans in about 5 minutes' time after a brief recess, and that concludes our business this morning. Our next meeting will be on the 28th of October. Thank you very much.